Okay, good morning. Welcome to session 1 of our Facilities and Business webinar series. This is Buying and Building an Overview of Bidding Requirements and Alternatives. This session is intended to be a somewhat introductory overview of bidding requirements, both related to construction projects as well as purchases of equipment and supplies and things like that. I'm going to start by discussing the bid limits and general bidding requirements, and then I will talk about some exceptions or alternatives to competitive bidding. Your questions are welcome. Please type them in the Q&A panel on the right-hand side of your screen. Your questions will only be seen by panelists, and we have reserved a few minutes at the end of the presentation to answer verbally as many questions as we can get to. I do have a lot of material to go over today, so to the extent I don't get to all of the questions, I do apologize. An evaluation form will pop up on your screen when you exit the webinar. Please complete the evaluation form so that we know how to improve future trainings. We consider all feedback important and we appreciate your input. Finally, this webinar is being recorded and we will send everyone a link to the recording after the event. We look forward to your participation in the next webinar in this series, Contracting with Technology. If you were unable to attend past webinars would like links to those recordings, please send an email to our Client Services Department, clientservices@lozanosmith.com, and request that the links be sent to you. Okay, and with that, I'm going to jump into the materials. As most of you on the phone probably know, the general rule is that absent an exception or alternative, bidding is required if a purchase exceeds the bid limit. So the first thing we need to determine is what is the applicable bid limit, and it depends on the type of products or services that are being procured. There are two, and let's just flip the slide here. There are two bid limits that I'm going to discuss. These are both found in Public Contract Code 20111, and they apply to different types of purchases. The first category applies to the following: equipment, materials, and supplies, services other than construction, and repairs including routine maintenance, landscaping, and minor repainting. Those categories of items apply a currently $84,100 bid limit. And that number is actually increased every year by the Superintendent of Public Schools. So if you were to go into the statute cited there, 20111A, you're going to see a reference to a bid limit of $50,000. That's what the limit was initially when the statute was enacted, and it's increased every year. So again, the current bid limit for these three categories of purchases is $84,100. The other bid limit in that section is $15,000, and that applies to public projects. Generally, when we say public projects, we are talking about construction, although the definition is slightly broader than that. And just one more note on the past slide, the $15,000 number is not increased annually like the bid limit applicable to equipment, services, and repairs and maintenance. So one thing I just want to cover here is the definitions of public project and maintenance, because there can be some overlap and some confusion between the two. Both of them are actually defined terms in Public Contract Code 22002. And the reason, again, that this is significant is because if something is a public project, it's going to be subject to the $15,000 bid limit. If something is maintenance, it's subject to the higher $84,100 bid limit. Public project is defined generally as construction, as well as the other items listed there: reconstruction, improvement, demolition, or repair work involving any publicly owned, leased, or operated facility. It also includes painting or repainting of any such facility. That is contrasted with maintenance, again subject to the higher bid limit, which is defined to include routine, recurring, and usual work for the preservation or protection of any publicly owned or operated facility. It also includes minor repainting, which is contrasted with just repainting, which is a public project. So there's definitely a gray area there. Maintenance also includes resurfacing of streets and highways at less than 1 inch. We've seen school districts use that definition when it comes to resurfacing or paving their parking lots or throughways on school district property. Maintenance also includes landscape maintenance, as well as certain work related to water, power, or waste disposal systems. So again, there can sometimes be a question of whether a certain project or certain work constitutes a public project or maintenance work. And in those cases, if you're really in a gray area and you can't figure out which it is, the first question you want to ask is whether the work is routine and recurring. If so, it's more likely going to be maintenance. But if it's really a close call, then the most likely conservative approach would be to assume that it's a public project and apply the lower bid limit. Or you can try to see if an alternative to public bidding might apply in your specific circumstances. We'll get into some alternatives in just a little bit. Okay, so we've talked about what the bid limits are and which bid limits apply to which types of purchases. Now I'm going to get into general requirements for bidding. So if you're above the bid thresholds under Public Contract Code 20112, the first thing that happens is that you publish notice in a newspaper once a week for 2 weeks. That notice will call for bids, and it will specify the time and place for opening the bids. The bidders then submit their bids under seal, and that's combined with bid security. And I do see that there's a question about bid bonds and whether bid bonds are required for non-construction bids, such as janitorial supplies. If you look at 20111B, that's the section that applies to construction bidding, and it specifically requires a bid security to be submitted with construction bids, or excuse me, public project bids, which is generally construction. And it doesn't have to be a bid bond. It can be cash, cashier's check, or I believe it's certified check, or a bid bond to the district. The same requirement is not contained in the provision that applies to other types of purchasing, like equipment and supplies. So technically, no, it doesn't appear that a bid bond is required for those types, including janitorial supplies. So moving on this slide, once the bids are received and opened by the district then awards to the lowest responsive and responsible bidder, or it has the right to reject all bids. And I just want to have a quick note on the responsiveness and responsibility issue, because this is actually a pretty hot topic. So again, you can only accept the low bid if it meets both of those categories. The responsiveness issue means that the bid conforms to bid specifications, and if it doesn't, it can't be accepted. Usually this is determined from the face of the bid. So for example, you have a bid and all of the questions are answered, all of the boxes have been checked that need to be checked, all of the pages are signed. That's going to be a responsive bid that can be accepted. If there's missing information, for example, failure to provide licensing information that was requested in the bid documents, that bid is going to be non-responsive and cannot be accepted. There is some room for school districts to waive minor variances in bids if it doesn't affect the amount of the bid or give an unfair competitive advantage to the bidder. So to give an example of that, if you have a bid package where everything looks perfect, but there's one place in the entire package that the bidder forgot to sign, and that failure to sign does not in any way affect their advantage in the bidding process, arguably the district can waive that failure to sign and go ahead and accept the bid. If a bid is rejected as non-responsive, there's no hearing required. The school district just notifies the bidder and gives them an opportunity to respond. So in other words, advise the bidder, hey, we received your bid, however, you forgot to or you neglected to include licensing information on page 3, therefore this is non-responsive, cannot be accepted. And then you're done, and then the district can award to the second lowest bidder. The other issue when determining the lowest bidder is responsibility. And what that gets at is whether or not the bidder is qualified and capable of performing the work. So this is different from responsiveness because generally responsiveness is determined based on the face of the bid, whereas responsibility is determined outside of the bid package. So this may be something like the district has worked with a contractor in the past, has had a very bad experience or multiple bad experiences with that contractor, and the contractor then bids on a subsequent project. The district doesn't want to work with them again. There's a possibility there for the district to reject the bid based on a finding of non-responsibility. But in this case, as opposed to responsiveness, there is a due process hearing required. So you don't just notify them, you have to actually give them a hearing. And just one more thing to note on responsiveness versus responsibility is that there's recent case law that has kind of blurred the line between what's a responsiveness issue and what's a responsibility issue. That's the Great West Contractors versus Irvine Unified School District case. And so just be aware that it's not always a slam dunk which is which and whether a hearing is required. The last item on this slide says no bid splitting. That's based on a provision in the Public Contract Code 20112 that makes it unlawful to split purchases or projects into smaller contracts for the purpose of evading bidding requirements. So in other words, if you have a project that's going to cost $20,000 and the district doesn't want to go out to bid on it, so it decides it's going to split it up into two separate contracts for $10,000 each, that's a pretty clear violation of this provision, and it's not permitted under California law. Now, sometimes you'll have situations come up where, for example, the district undertakes a $10,000 project on a particular school site. After completing that project, the district might decide that another project is warranted. That's also $10,000. And if you've got good backup documentation showing that the decision to go forward with these projects came up at different times, they were never one project that was split up, you have a much better argument that you're not engaging in unlawful bid splitting. And that sometimes can be a very fact-based analysis, so just be careful if you ever feel like there are multiple contracts relating to each other, just be careful and be aware of this issue. Okay, the last item on general bidding requirements, sole source specifications. Public Contract Code 3400 generally prohibits specification of a brand or trade name in your bid documents unless you use the words or equal. And there are exceptions to that rule. They are as follows. For field tests to match other district products in use within the district, where a product is only available from one source, or in the case of an emergency. Okay, on that note, I'm going to give a brief overview of some of the construction bidding requirements. This is more or less a recap of what we've already covered, and then I'm going to be jumping into alternatives to competitive bidding. So for construction, we already discussed that if a project exceeds $15,000, then it is required to be bid unless an exception or alternative applies. As a caveat, that bid limit, the $15,000, applies to school districts that have not elected to become subject to the California Uniform Public Construction Cost Accounting Act. And as you can see, that is a mouthful, so we usually refer to it either as cupcake, because the letters almost spell out the word cupcake, or some like to refer to it as uniform cost. So further down in the presentation here, I'm going to be referring to that as most likely cupcake, so know that this is the act that I'm talking about. Where districts have elected to become subject to cupcake, they are subject to different bid limits when it comes to construction projects and different rules as well. The traditional method for bidding construction projects is what we call design, bid, build. What that means is that the district typically will first go out and hire its architect or design professional to design the project and draw up the plans. Once those plans are completed, the district uses the plans to go out to bid, and then it selects the contractor through the bid process, who then builds the project. So that's the traditional method, and the reason that I mention that is because we're going to contrast it with a couple of alternatives later on in the presentation. When you go through the design, bid, build traditional method, there are a whole bunch of documents and forms that you need to be thinking about. I've listed some of them here as well as on the next slide. There's a lot here. I'm not going to go into detail on each individual one. Some are self-explanatory. We've already talked about the bid bond. Of course, you'd have your bid form and contractor agreement, designation of subcontractors. At the bottom there, you'll see payment and performance bonds. Just note that a payment bond is required for any project over $25,000. A performance bond, on the other hand, is not required in most circumstances, although there is at least one limited circumstance that requires performance bond. but we do recommend performance bonds generally for any school district construction project. And in addition, you're going to have, for construction projects, you're going to have various declarations that have to be made by the contractor, for example, non-collusion declarations, potential fingerprinting notices and acknowledgments, DVBE or Disabled Veteran Business Enterprise worksheet, good faith effort worksheet, and certain certifications that may apply as well in depending on the type of project at issue. Okay, so I've given you kind of an overview of general bidding requirements and thresholds, and now we're going to spend the rest of the time talking about alternatives. And there are quite a few here, which is why we've reserved more than half of the presentation today to discussing them. Many are used pretty commonly by school districts, and I'm going to try to mention with regard to each one both the context that it applies, because some of these exceptions or alternatives might apply in different types of, for different types of purchases. And I also am going to try to point out some of the nuances that will apply if you're trying to use an alternative to competitive bidding. So the first alternative is what I referred to earlier as CUPCAKE, or uniform cost. And you've got the whole acronym there and what it stands for, as well as the citation in the Public Contract Code to the sections that are that govern this act. And once a district, I'll talk a little bit more about how the district becomes subject to CUPCAKE, but once it is subject to CUPCAKE, the following bid limits apply instead of the $15,000 bid limit that I talked about earlier. And just a reminder again, because I have seen some confusion with this, if you're a CUPCAKE district, these bid limits apply for construction projects, but you're still going to be subject to the same bid threshold and rules as any other district with regard to other purchases such as equipment, materials, and supplies, services other than construction, and maintenance. So just keep that in mind. We're only in the construction context here, or the public project context. So the new bid limits for you to be aware of under CUPCAKE are $45,000 or less, there's no bidding required. $175,000 or less, there's an informal bidding requirement, and more than $175,000, you'll be subject to formal bidding requirements. And obviously, I'm going to go into more detail on all of those. So the first is those projects under $45,000. Under CUPCAKE, a district can perform the work using its own employees, which is basically called force account, or through a negotiated contract with a contractor of choice or purchase order. So there's no bidding requirement. And I skipped over this, but just so everyone's clear, if a district wants to become subject to the uniform cost or CUPCAKE scheme, then the board has to elect to do so by resolution. Okay, the next threshold under the CUPCAKE scheme is the $175,000 or under projects, or under $175,000 projects. In that case, there's an informal bid process that is required. And how that works is, first of all, the board has the authority to delegate to awarding authority to an appropriate staff member. The district maintains a list of qualified contractors by the category of work, and then it mails notice inviting bids to everyone on that list or to all trade journals designated by the Uniform Cost Accounting Commission. And the district may then award to the lowest responsible and responsive bidder or reject all bids. And there's a lot of text here, but basically remember that under CUPCAKE for informal bidding, if the original estimate is $175,000 or less, but all of the bids come in over $175,000, the district may still award up to $187,500 if the estimate was reasonable, the original estimate, and the board approves the purchase by a 4/5 resolution, a resolution adopted by 4/5 vote. As with any type of construction bidding or other bidding, the district always has the right to reject all bids. Under CUPCAKE, if the district rejects all bids under the informal bidding procedure, it can either abandon the project completely, re-advertise for bids, or declare by 4/5 vote that the project could more economically be performed by its own employees, in which case notice must be given to the apparent low bidder. And if no bids are received at all, the project can be performed by the district's own employees or through a negotiated contract. Okay, and then the third kind of threshold or category under Cupcake is formal bidding, which is required for projects over $175,000. This is a formal bid process. The district first adopts plan, specification, and working details for the project, and then the notice inviting formal bids is published in a newspaper and sent electronically, if available, and mailed to all construction trade journals designated by the Commission. That's the California Uniform Public Construction Cost Accounting Commission. The district then must award to the lowest bidder or reject all bids, similar to the informal procedures. If it does reject all bids, it can abandon the project, re-advertise for bids, or declare by 4/5 vote that the project could more economically be performed by its own employees. And again, if no bids are received through the formal procedure, the district may, the project may be performed by the employees of the district, by force account, or by a negotiated contract with a contractor of the district's choice. Okay, so just to recap briefly to make sure there's no confusion, I've covered kind of three different thresholds, I guess, for bidding that may apply in different circumstances. The first was the $84,100 that applies to our equipment, materials, and supplies, services, and maintenance. And then in the construction context, there are two separate bid threshold schemes that may apply. For non-Cupcake districts, it's $15,000, and for Cupcake districts, it's the $45,000, $175,000 informal versus formal bidding. I mention that only because even in my experience thus far, I've seen more and more districts becoming or electing to become subject to the Cupcake or uniform cost procedures. And I've also had quite a few questions about them, so there's definitely a lot of interest there. I've also been told recently that sometimes districts aren't even aware of whether or not they certain people within the district are not aware of whether or not they are subject to the Uniform Cost Accounting Act. So if you are at a district and you're not sure, that would be something definitely to find out. So with that, we're still in the construction realm. I'm going to move on now to two alternative delivery methods. So previously in the webinar, I mentioned the traditional design bid build method. These are two other construction delivery methods that can be used by school districts when certain conditions are met, and neither of them require traditional competitive bidding. First is lease-leaseback. Many of you have probably heard of this. It's based on Education Code 17406. And what that section essentially says is that a district can lease property it owns for $1 a year to a contractor who builds school facilities on the property, and title to those facilities vests with the district at the end of the lease term. The district then, symbolically at least, leases the property back from the contractor and pays for the construction through those sublease payments. Two things to note about lease-leaseback. First is that the district is required to have approved plans, approved by DSA, before it enters into a lease-leaseback contract. A lot of times we have districts that want to enter into or want to start its contractual relationship with the contractor earlier on in the process, because they want to foster a more collaborative approach with the architect and the contractor. That can be done through the use of a pre-construction agreement as opposed to entering into the actual lease-leaseback contract too early, because again, you're not supposed to do that under the law until after you have your approved plans in place. In some ways, the lease-leaseback process might work a lot like the traditional design bid build method, except that you don't necessarily go out to bid for your contractor. But essentially, you would start by engaging an architect to draw up plans. Those plans would be approved, and then the contractor would be selected and would build the project based on the approved plans. As I said with lease-leaseback, you're not required to competitively bid the project. It's optional also to use an RFP or request for proposals process to select your contractor. Although that's technically optional, we recommend it because obviously the district wants to make sure that it's getting the best deal or it's getting competitive pricing for its project, but also there is some public perception that tends to be negative towards lease-leaseback, and you want to make sure to avoid an impression of favoritism or something along those lines. But like I said, the advantage with lease-leaseback is that it tends to be a bit more flexible than the traditional method. Okay, and then one other construction delivery method that's available to school districts is design build. The difference here is that rather than entering into separate contracts with your architect and your contractor, the district would actually enter into a single contract with a single entity that performs both the design work and the construction work. And this process is authorized specifically by the Education Code. I've got the citations there on the slide. The limitations are that the project has to be at least $2.5 million in order to use design build. And there are, while technically no traditional competitive bidding is required for design build, there is a very detailed process that applies to this type of procurement. So please be aware that just because it's technically an alternative to competitive bidding, there's still pretty involved process that you have to go through. And what that essentially involves is that the board first must evaluate the design build method as compared to the traditional design bid build method at a public meeting, and determine that the design build method is in the best interest of the district. The board also has to make a specific written finding that design build will meet one of the following goals. Either it will reduce costs, it will expedite construction, or it will provide some feature that is not achievable through the design bid build method. After all of that is done, the board adopts a resolution approving the use of the design build method, and then there's a very detailed RFP or request for proposal process that the district has to go through in order to award the contract. There's also this requirement at the end of the project that the district has to submit a detailed report to the Legislative Analyst's Office regarding the use of design build on the project. Okay, so changing gears slightly here, we've been talking a lot about construction projects and also alternatives to bidding construction projects. I'm going to take you through some kind of different contexts here, the first being technology. There are a pair of provisions in the Public Contract Code that provide exceptions for bidding for certain types of technology items. I'll talk about each one in turn. The first one is Public Contract Code 20118.1, and the application of that section is to electronic data processing systems and supporting software. For those items, the district still has to go through the competitive bidding process, but it is allowed to select one of the three lowest bidders as opposed to just going with the lowest bidder. The other exception is Public Contract Code 20118.2, and that section applies to the following: computers, software, telecommunications equipment, microwave equipment, and other related equipment and apparatus. So as you can see, that definition is a little bit outdated, as is much of our legal scheme with regard to technology, because as most of you probably know, technology is developing much quicker than the laws are changing. But in any case, if you have a purchase that's going to fall into that category, there's a competitive negotiation process that can be used instead of competitive bidding. So note, please, two things about this provision. Number one is that the competitive negotiation process still has strict rules that have to be followed. There's still a process that's outlined in that section 20118.2. essentially it's an RFP process, and it requires a particular board finding. The other thing to remember with 20118.2 is that it cannot be used for items that are available in mass quantities to the general public. So the way we like to explain that is if it's an item that you could go down to your corner Office Depot or Fry's and purchase, it's not going to be subject to this exception. It's most likely going to be governed by the traditional competitive bidding rules. Okay, so moving on to emergencies, this is another potential exception to bidding requirements. And this applies where the district is allowed to dispense with competitive bidding where it's necessary for the continuance of classes or to avoid danger to life or property. The rules are slightly different here depending on whether or not the district is a cupcake district or not. Generally, for non-cupcake districts, the emergency exception is governed by 20113 of the Public Contract Code, and that requires a unanimous board approval as well as approval by the county superintendent before the district can go forward with the contract in the case of an emergency without competitive bidding. The rules under cupcake are cited there, and the major differences are, number one, the district only needs a 4/5 vote of its governing board. The other difference is that the cupcake district does not need county superintendent approval. The nuance with emergencies is that there was a case in 2004, Marshall versus Pasadena Unified School District, that kind of added to the requirements in the case of an emergency. And what that case essentially held is that in order to dispense with public bidding in the case of an emergency, the emergency has to be caused by a sudden and unexpected occurrence. That definition comes from a definition in the Public Contract Code and Section 1102 of the word emergency. And what happened in that case is that the school district was building a new school. Sometime midway through the construction process, the district got into a dispute with the contractor. And as a result, the district terminated the contract. The contractor walked off the job without finishing the project. A few months went by, and then school was going to start, and the district didn't have a completed school. So it considered the situation to be an emergency and attempted to contract to complete the work without going through the bidding requirements. And the district was challenged, obviously, in that case and lost. The court said this was not an emergency because the school district knew of the situation for at least a couple of months or so before it decided to do something about it. It was not based on a sudden and unexpected occurrence, and therefore bidding was required, or potentially another exception could have applied. Okay, another exception to bidding is under Public Contract Code 20114, where the district can use its own employees, which is what force account means, to make repairs, alterations, additions, painting, decorating, or things along those lines. The limitations are that it's the district with more than 35,000 average daily attendance. The limits are $21,000 for cost of materials and 750 total hours, and that's per project or for the particular work. And districts with less than 35,000 ADA, the limit is 350 total hours. That one's pretty straightforward. Another exception may exist to competitive bidding in particular circumstances based on a public policy exception that's been created by the courts. Now, we all know that the competitive bidding laws are there because we want to ensure that school districts are getting the best pricing. Obviously that's a benefit to the district as well as the public. And in certain very, very limited circumstances, those objectives may just not be met. In those cases, it's possible that the courts would find an exception based on this public policy idea that competitive bidding is not going to produce any advantage or is practically impossible. So my caveat here is that this is reserved for very unique circumstances. It should be used very sparingly. It probably should only be used after consulting with an attorney. And that's because it is reserved for unique circumstances, but it's also fact-based, so it's going to be unclear whether or not a court is going to agree that there's no advantage to competitive bidding in a given set of circumstances. So if the district has a situation where it thinks that there's no benefit or there's no advantage, and it goes forward without bidding and gets sued, it can be a gamble as to whether or not the court's going to agree. The case that's often cited for this proposition is Graydon versus Pasadena Redevelopment Agency. And what happened there is that the redevelopment agency was building a very large shopping complex, and the last item to be built was the parking structure. And until that was built, the entire complex could not open and begin operating. And they needed to open the complex immediately in order to pay down bonded indebtedness on the project. So the time that it would have taken to go out to bid for the parking structure would have cost them so much money that there was absolutely no advantage in that case to competitive bidding the project, so the court allowed it to go forward. Okay, professional services are also not subject to competitive bidding. That's in 20111C of the Public Contract Code. Also, Government Code 53060 elaborates on this by allowing contracting for special services or advice, and in that provision specifically elaborates on what these professional or special services are. And it lists financial, economic, accounting, engineering, legal, or administrative matters. Note that generally you're looking for professionals or consultants who are specially trained and experienced and competent to perform the special services. So in order to fall under this category, you're looking for things like education and training, maybe an advanced degree, licensing tests, things like that. Okay, cooperative purchasing, this is a big one. The first category there, piggybacking, I'm sure most of you have heard this term before, probably have used it. It's not a legal term, it's just a common term used for this type of bidding alternative. And it's based on Public Contract Code 20118. And what that section allows is for a district to enter into an agreement with a vendor based on an existing agreement between that vendor and another public agency. So in other words, if there's a neighboring school district that just went through a bidding process for supplies, entered into a contract with this vendor, your district can enter into the exact same contract with the exact same vendor without going through the bidding process. Note that piggybacking only applies to personal property, so this cannot be used for construction projects. And there are a couple of requirements that apply that are sometimes overlooked. One is that technically the board is supposed to determine that the contract is in the best interest of the district before it's entered into. So typically that can be done by when the board approves the contract. There's a staff report or something to that effect that says right in it why this is in the best interest of the district, and then the board, by approving the contract, is making that finding. It can be as formal as actually having a resolution in place for the board, although that's not technically required. The other thing to remember with piggybacking is that the district's required to enter into the contract on the same price and terms as the existing contract that's being piggybacked. So if the obvious issue is if you have a contract that you want to piggyback but you want to negotiate the price, well then technically you're no longer entering into it on the same price and terms, and you're actually definitely no longer going to be within the piggybacking statute. A less obvious example is that there's a lot of piggybacking going on with out-of-state contracts. And so what sometimes happens there is that the out-of-state contract has a clause in it that says, for example, any dispute will be decided in the courts of Minnesota. And that's something that we typically recommend school districts not accept, because if there is ever a dispute, the district doesn't want to have to go defend or prosecute a lawsuit in another state. So that may be an easily negotiable term with the vendor, but at the point that you're changing a term, it is not clear that you're still following the requirements of the piggybacking statute, because now technically you've got different terms in there. I'm not saying this is not ever done. It is done. It's a risk-benefit assessment. Changing a very small term might be less egregious than changing, say, a price term or something along those lines, but there is very little guidance in this area, so just be careful before you're doing anything like that. The other thing on this slide is CMAS and WSCA. CMAS, California Multiple Award Schedules. It's based on a pair of sections in the Public Contract Code that allow the Director of General Services to consolidate the needs of multiple state agencies through master agreements, contracts, and award schedules, and then make those schedules available to local agencies like school districts. And CMAS is only applicable to goods, services, and information technology. So again, you're not going to be using a CMAS contract for a construction project. I will get into a quick caveat in just a second on that. And like piggybacking, if you're using a CMAS contract, then you're going to be required to go with the same price and terms from the vendor. And WSCA is the same idea. It's Western States Contracting Alliance. We get a lot of questions about what if you have a CMAS contract or a WSCA contract where it's for equipment, but there's an installation or labor component to the contract, and can you still enter into the contract without competitive bidding? And there isn't a clear, definite answer on this, but there is at least some guidance that can be applied by analogy. There's a case called Steelguard Inc. versus Janssen, and since that's the one I don't have up there, it's 171 Cal App 3rd 79. And that case does not relate to school districts. It's decided under the State Contracting Act, but we use it by analogy. And basically what that case said is that if the labor and installation piece is only incidental to the overall purchase, then it's permissible to treat it as a non-construction contract. And the question is, what does incidental mean? In that case, the state agency was using a 10% rule, which basically if the labor installation piece was less than 10% of the overall contract, then it was presumed incidental. If it was more than 10% up to 50% of the contract, it's presumed not incidental. And in those cases, the district probably wants to make a specific finding if it's going to try to still go forward. But there's probably going to be risk there. If it's over 50%, then it's most likely not going to be incidental, which is pretty common sense. And the district should treat it as a construction contract. Okay, design professionals. Again, this is your architects, your design professionals, engineers. These types of professionals are not subject to competitive bidding, but there are still requirements that apply. You can't just go out and pick anyone you want. There is a competitive process that applies. I have got some statutory citations up there for the particular provisions that apply, and it does depend on, the specific process does depend on whether or not state funding is being used in the project. Okay, energy conservation contracts. This has been kind of a hot topic lately given Prop 39 funding and the regulations that were promulgated under the Prop 39. As background, Government Code 4217.10 et sec has essentially contains exceptions to competitive bidding for energy conservation contracts. And that's specifically defined in those terms. However, Prop 39 was recently passed, somewhat recently, and created funding for projects creating clean energy jobs. The legislature then implemented regulations to implement Prop 39, and one of the laws that was enacted is Public Resources Code 26235C, And what that section says is that educational agencies may use the best value criteria, as defined in Section 20113 or 133, for contracts awarding Prop 39 funds, but the district shall not use a sole source process. And there is no guidance in the law as to what sole source process means in this context. And in fact, it could even alter the normal bidding process for architects and design professionals, since that's where you see that type of language. So, until there's guidance on this, the best advice is that districts can decrease their risk slightly by increasing the competitive process used whenever Prop 39 funding is being awarded. And another possibility would be to fund design professionals with non-Prop 39 funds, if that's even possible in the district circumstance. Okay, perishable foods and seasonal commodities. Under Education Code 38083, there's an exception to public bidding for contracts awarded for these types of items, perishable foods and seasonal commodities, if the contract is awarded per district rules and regulations specific to such purchases. So in other words, the district has board policies or other regulations on point related to this type of purchase. Now, I have a huge caveat to give with this exception, because many districts use federal funding under, for example, the National School Lunch Act or other similar federal programs. And if the district is using those type of funds, then there is a whole scheme of federal regulations that apply and require competitive process. And those regulations are very dense and very complicated, but just keep this in the back of your mind if you ever hear somebody say, or if you ever are purchasing perishable foods and thinking that it's exempt from bidding, make sure to ask yourself what type of funding is being used to procure those items before you dispense with public bidding altogether. Okay, and then just a couple of other more maybe obvious or less common bid exceptions that I just want to mention here. Instructional materials under 20118.3, those are exempt from public bidding. Surplus property from the federal government under Education Code 17602. And under Ed Code 39802, transportation contracts over $10,000. Generally, those must be competitively bid, but the rules are a little bit different at that point, and the district is not necessarily required to go with the lowest bidder. Okay, so that wraps up the materials. I see that I have a couple of questions here. If you just give me 1 minute to look through them, I will answer as many as I can before we end for the day. Okay, so I have a question here about the risks of the lease-back method of delivering a construction project. And I touched on this briefly, but again, the advantage of lease-back is that it's a bit more flexible in terms of the bid process. The biggest disadvantage or risk is that there does tend to be, especially depending on what community you're in, there does tend to be some public disapproval. There have actually been some recent cases filed challenging the use of lease-back, and while so far all of those cases have been unsuccessful in overturning or in challenging the use of lease-back by school districts, that has been going on. So I think the biggest risk is more of a political one than a legal one. And certainly, the other risk, I guess, to mention is that since there's no bidding requirement, there could be a risk that the district enters into a contract and ends up paying, overpaying for the construction project by quite a bit of money. And then, like I said earlier, that can be decreased if the district goes through at least some sort of competitive process, like an RFP process, for example. That can be very helpful to decreasing some of these risks. I also have a question about perishable foods and whether that includes liquids like milk. The perishable food section of the Ed Code doesn't define perishable foods, it just refers to them. So I would say arguably it might include milk. Note, however, that same caveat applies that federal funding, there are some regulations that apply specifically to milk. So I would be very, very careful before trying to use that exception to apply to the purchase of milk. And last question I wanted to just touch on here is for Prop 39. The question is, where do school districts stand in regard to sole sourcing under Prop 39 if they utilize their COE and the COE's consultant for their Prop 39 needs? I have to say I don't know the answer to that. I think it's a very good question, but the same kind of analysis is going to apply. Since we don't know what sole sourcing means specifically, we can't tell you whether or not what you're doing is right or wrong under the law. So again, the best way to decrease the risk is by trying to increase the competitive process that's being used. So one thing to ask or to look at is, how is the COE selecting the consultant? That would be my advice as far as starting place. And I've got one more question I'm going to cover here. That just came through? What is the just disappeared. What is the bid threshold for technology procurement? So technology is more likely going to be equipment, materials, and supplies, which is going to be subject to the $84,100 bid limit that we talked about. And again, that changes every year. But note the two exceptions that may apply for technology purchases. I talked about them. They're in the slides. Public Contract Code 2011, 8.1 and .2. Those exceptions may potentially apply to technology procurement. And if they do apply, then the bid thresholds become irrelevant because you can actually, I shouldn't say that, because under 2011.8.1, you're still required to competitively bid. Under the other one, if you're going to go through the competitive negotiation process, there's no bid threshold. So the next question here, and again, we're almost out of time, so this will be the last one I'll get to. What constitutes a category for a bid limit? For instance, computers, laptops, iPads, printers, cables are all technology items, but do they all fall into the same category under the $84,100? I would say generally yes. Where you might get into construction issues again is if, for example, you're ordering cabling or other types of technology and there's installation component as well. When you get into those situations, then you have to think about whether or not the installation is incidental to the overall contract. But aside from that issue, if you're just looking at technology equipment, whether it's computers, printers, those are generally going to fall under the $84,100 bid limit unless you're using an exception. And with that, we're just about out of time here, so thank you very much for attending today, and I hope it's been helpful to you and that you will think about all of these issues when you are going through your purchasing and construction needs in the future. Thanks very much.